And lift off. Here you go. Oh, God. Hi, guys. How are you? It's Cathy Walters of Compass. I'm here with my friend Chris Bratton of Bratton Attorneys at Law. Today, we're going to talk about will and estate planning, right? Thank you so much, Chris, for joining us today.
Have me on?
Yeah, of course. Are you staying warm? It's so cold out. My God.
Yeah, I'm tired of shoveling snow. Yeah, for sure.
Dude, you know we're gonna get 5 out of the next 7 days snow. Oh
I
my
know.
God. Oh
I
my
know.
God. All right. So the point of today is to talk about all things estates and wills. So let's just get started. Power of attorney. What is the difference between a general and a limited power of attorney?
So, and what we'll also do is try to tie this into real estate and then how that affects all your real estate.
Oh my God. Big time.
Because we can go down rabbit holes just with regard to estate planning and estate administration. So we'll try to keep it tied in close to what you do.
Thank you.
So, there are times when people can't attend closing for whatever reason. Maybe they're out of town. Maybe they don't want to go to closing. Maybe they're incapacitated. Maybe they're older, ambulatory issues, can't get to closing. It could be a host of reasons why someone can't go to closing. And do a lot of other things, financial transactions, banking transactions, paying bills, whatever the case may be. So that's where we utilize the power of attorney. And you'll hear it termed a general durable power of attorney. A lot of times general just means that it's broad in scope. Durable means that it survives in capacity. So you can have a general power of attorney or you can have a limited power of attorney. Typically with a limited power of attorney, you see a lot of that in real estate transactions where the principal is giving the agent under the power of attorney the ability to handle that particular closing and only that particular closing. And after the closing, the power of attorney is no longer in effect. Or you can have a general power of attorney, which gives that agent broad powers to do multiple things, whether it's buying and selling real estate, handling financial transactions, dealing with insurance, retirement accounts, whatever, for an unlimited period of time. So that could be all the way up until the person passes away. So in either the case, you can utilize those for real estate transactions, whether you're purchasing real estate or whether you are selling a piece of real estate. And if you're going to do that, if you're closing on a property, whether purchasing or if you're selling a piece of property and you're utilizing that POA, number one, you want to make sure the title company has a copy of it in advance so that it's approved by the title company. And then whenever you're signing the deed, if you're signing this POA, the clerk, whenever you send the deed in to be recorded, they're going to want a copy of the POA as well because they're going to record a copy of that power of attorney along with the deed. So you have to make sure that everything is, that the power of attorney it gives the agent the powers that they need and that the execution requirements are adhered to. And the basic execution requirements are that it has to be notarized.
Right.
Giving the power has to sign it in front of a notary, and the notary will acknowledge it. And then it's in New Jersey, at least, that's what's required.
And so is that something that someone would go to an attorney to get? Is it something that they can have the title company prepare? Is it something they can prepare themselves?
Maybe all three. I don't know if the title company prepares them or not. They may utilize forms. So, but they can.
They're going to send me to you.
Yeah. The attorney can prepare it, or there are websites or forms that you can use online if you're trying to prepare it yourself.
I personally don't really advise that. I like for an attorney's eyes. I mean, if it's that easy, kind of worries me. I feel like there are loopholes.
The problems that we run into with people using it on forms, it doesn't give the requisite power that the title company needs or the recorder's office needs sometimes. Sometimes you just run into issues and then it becomes a problem with closing. So we don't have an attorney take a look at it yet.
Right. So I like to mitigate all of those issues and just go to my friend Chris and get that done.
Right. At closing, you want it to be smooth in and out. Everybody's happy, right?
In my opinion, closing is just a formality. We're in 10 minutes out, unless everyone wants to talk and schmooze and like rub elbows these days. That's cool. We can do that. And then there is something also, I cannot remember what it's called. It's not really the power of attorney, but if the seller signs the deed and then they give me, what is that called? And then I could sign the ALTA for them. And so I feel like people get that confused with a power of attorney, which are not the same.
I don't know of anything that's going to give you the authority to sign something on their behalf other than maybe a limited POA.
Yeah, it must be a limited type of POA, but I don't, anyway, I have to look into that. That's something that the title company does prepare. So let's talk about guardianship. When is that required and what's allowed?
So if you haven't planned ahead and there's not a power of attorney in place, then unfortunately we have to go to court to obtain a guardianship. So if someone doesn't have the requisite capacity to understand what they're signing and give those powers away under a power of attorney, then they can't sign it. So essentially a power of attorney is like a contract between the person giving the powers away and the person accepting those powers. So you have to have, the principal has to have the ability to understand what they're doing, the powers that they're giving away to that person. If they can't do that, then they can't sign the POA. So then if they can't sign the power of attorney, now we're in a situation where we have to go to court. And a guardianship is a court proceeding. You have to petition the court for guardianship over the incapacitated person. You're probably, I would say, from start to finish, by the time we're trying to get the doctor certifications, everything else, probably a 3-month process. Especially now, given that there's a bit of a backlog and with COVID and everything else, a lot of things virtual. So we have to file a complaint, order to show cause, certifications, get the doctors to two doctors to certify that the person is incapacitated. You submit that to the court. The court then appoints an attorney to represent the alleged incapacitated person, and they give you a court date. That court-appointed attorney is going to interview the alleged incapacitated person. They're going to interview the person that's seeking the guardianship, maybe other family members, and then they are going to write a report to the court. And now, you also have to understand that you have to give everybody notice. So let's say that there's 3 kids, and one of the children are seeking guardianship of mom. You have to give notice to the other 2 kids of the proceeding that's happening. And if they object, now potentially you're looking at a further, like more of a litigious type scenario, which is going to take longer because now we have discovery deadlines, court dates, things of that nature. So it could go smooth, it could not, but I would say you're at least looking at a 2 to 3 month period where before you can actually get the guardianship. And you have to ask permission from the court to sell real estate. So even if you go in and let's say that you got a guardianship today, but you're not selling the property until a year from now, you still have to go back to court and ask the court for permission to sell that real estate. You're not allowed to sell real estate without permission. So you do have to ask for that permission, and then it will be granted by the court, assuming that's appropriate. So that can delay closing quite a bit if you don't have that in place.
Right. So you're saying like my kids can't just go sell my house?
Lucky for you.
Yeah, lucky for me.
Good.
Oh my gosh. Oh, gifting a sale for $1. Can we talk about that?
Yeah, a lot of times we see more along the lines of elderly people. They want to start protecting assets. And for the main reason is really for fear that they're going to get sick and go to a nursing home. They're going to lose all of their assets. And that's a legitimate fear because nursing homes are expensive.
Right.
So what they'll do is they'll give away their house to their child, or they'll come to me and they say, well, what if I sell it for $1? It's still a gift, right? If you sell it for less than fair market value, whatever that amount is for less than fair market value, that's considered a gift, especially for Medicaid purposes. So there's a host of issues that go along with that, with giving that away or selling it for $1. And in almost all circumstances, we don't advise that you give it directly to the kids. If you want to protect it, we're all for it. We can protect it for you, but we would rather utilize a trust where we still have some control over it. Now, again, like as I said before, we can go down a rabbit hole with the different types of trust. But it has to be a special kind of trust, right?
Okay.
But, we can preserve a step-up basis, a lot of things that we can do. So if you gift it directly to the kids, there's a lot of problems there. Number one, there's going to be a carryover in basis. So your cost basis in the real estate is what you purchased it for. So if you bought that piece of property 40 years ago and you paid $20,000 for it, and now it's worth $220,000, you have a built-in gain, an unrealized gain there of $200,000. When you give it to your child, now that child has a cost basis of $20,000. And then ultimately, if they sell it, they're going to pay a capital gains tax on that $200,000, right? Whenever they sell, whatever fair market value is when they sell it.
Right.
So that's a big tax issue that we would want to avoid. The other problem is, well, if you give let's say that you give and this is a real life scenario that happened. Mom gives her real estate to her child. She doesn't do it in trust. She doesn't reserve a life estate, which is a lifetime right to the property. And the son passes away. And his will is now going to control where that property goes.
Real estate.
He gives it to his wife. Well, the daughter-in-law must have maybe she didn't like mom very much. She kicked mom out of the house and then sold the real estate. So, there's a host of, your son could pass, your child could get a divorce, they could run into creditor issues, they could file for bankruptcy. There's a whole host of things that can go wrong in that scenario that can be avoided if we utilize a trust instead. And again, we can address the tax issues, we can address those death issues, we can address all of those things and avoid all those pitfalls.
Right. And I am a huge believer that you get this set up like when you purchase your real estate. First piece of real estate, because tomorrow is not granted. The rest of today is not granted. Anything can happen. And so, that's just one small example. And then how about something, two people own a house together, one person passes away unexpectedly, and then the other person passes away and there's liens against the property that nobody knows about. And now there's no will. There are all of these things that we have to now try to navigate through, which makes it really, really complicated.
Even at a base level, everybody needs a will, a power of attorney, a healthcare power of attorney, a living will, and a HIPAA. Everybody, right? Even if you're 18, now you're an adult. Even if you don't have any assets, okay, maybe you don't need a will, but you probably need a healthcare power of attorney and a HIPAA, because if your child goes off to college and this child is 18, the college is not allowed to give you any information. If you've ever tried to call and say, hey, what are my kids' grades? Or if you've ever tried to hand out any medical information, good luck. They're not going to tell you. Unless you have that healthcare power of attorney in place or that HIPAA release in place so that they can give you information, you're not going to get any information. Even though you're paying for it, they're not giving you any information. Your child's an adult.
And you're going to continue to pay for it.
That's right.
Oh my God. It's so important. I feel like people do not think about that enough. And as much as I preach and I harp on it, it's like one of those things, out of sight, out of mind, that's not real, etc. But I feel like even now in the past year, it's even that much more important and imperative to make sure that you have your will in place, like all of these things that we just spoke about.
You never know, especially right now with everything that's going on. You don't know what's going to happen. We literally just had a client who we prepared documents for close to 5 years ago, and we kept contacting them, and they kept putting it off, and they didn't want to sign, and they weren't sure what they want to do, and this lasted for years. Now the husband took a fall down the stairs, and now there's issues, and they never signed their documents. So you just don't know what's going to happen. Get it done, put it away. It's, you're all set up. Revisit it every 5 to 10 years if you need to. Take a look at it, but at least you have it done.
Right. Or when there's a life change, right? Like, so
Yeah.
I like to say like every 5 years, just as a basis, like as a maintenance plan, right? And then if you get married, if you have a child, if you have a divorce, if someone dies, if whatever it is, these are all like just basic maintenance of adulting.
Right. Right.
um, da, 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 da. Did we talk about life estate versus no life estate?
No. So, and this is confusing for everyone, really, especially title companies and realtors, unfortunately. So, a life estate is a lifetime right to the property.
Right.
So, if I have a piece of real estate and I give it to you, I'm giving you a remainder interest, and I'm going to keep a life estate, which means I have a lifetime right to live there. I can rent it out. I can do whatever I want to with it. I get my rebates, my deductions. If I pass away, you're going to get the property with a stepped up basis. A life estate just means I have a right to be there for the rest of my life, and you can't ever kick me out, right? But the value of that life estate is based on actuarial tables that are produced by Social Security. So every year that I get older, the value of my life estate interest goes down because my life expectancy goes down every year I get older. So when you sell a piece of property and you have a life estate in it, when it's sold, the title company needs to know the remainderman gets a percentage of the proceeds from the sale, and the life tenant gets a percentage from the sale. A lot of times we'll see title companies just cutting checks to the remainderman, and that then is considered a gift because the life tenant was supposed to receive a piece of that. And that's something then we have to go back and cause problems for us if we're looking at potential Medicaid issues or IRS issues, what have you. So that's important for title companies to realize that, listen, if they see a life estate when a property is being sold, that needs to raise a flag, and like they probably need to get some more information. Maybe go to the attorney and say, look, how do I calculate these proceeds now? How are they going to be split up?
And how far back does Medicaid look?
5 years. They have a 5-year look back.
Okay.
Yeah. Now, it doesn't mean that we can't protect assets within that 5 years. It just means that they want to see what we've done within those 5 years.
Right.
And there's that's a whole other conversation.
Another article?
Yeah.
Versus no life estate.
So if you don't retain a life estate, it's like we talked about before, right? You're just giving your interest away and you don't have a right. So if I give you my real estate and I don't retain any right to it, it's your real estate. If you don't want me there, you can kick me out, you can sell it, you can mortgage it, you can do whatever you want to with it. So people need to be careful on how they give away real estate and what they retain and who they're giving it to.
Gotcha. And then we talked about the distribution when the property is sold. All right. Then the will versus the no will. You want to talk about that?
Yeah, this causes problems.
What happens in each situation?
Yeah,
People listen to this.
We just so you know, obviously you want a will to make sure you're either going to have a will or you're going to have a revocable living trust. In New Jersey, most people just have wills unless you have property in multiple states, or if you're more of a high profile client and you don't want your affairs known, then you would have a revocable living trust because once you probate a will, it's public record. But you do want something, either a revocable trust or a will to make sure that your distributions, your wishes as it relates to your estate are adhered to. Because that's going to lay out who the executor is, who the beneficiaries are. And then that executor is going to have the ability to then sell real estate. Now, we'll talk about waivers and what you need for the waivers and things like that. But if you don't have a will and you're in the process of selling real estate, everything's on hold, right? Or even if you do have a will, it's on hold for a bit. Yeah. But if you don't have a will, now someone has to apply to be administrator of the estate. They have to post bond. You have to give notice to everyone else that's on equal plane with you. So again, let's say there's 3 kids. If one of them wants to be administrator and the other the other one doesn't want that person to be administrator. Now there's a potential fight that's going to go to court. So it just creates more complicated issues.
Talk about this scenario. So in the event that both owners die, right, in the house, and how about this? Wait, let's backtrack. Say one party on the deed passes away, right? And there's the other party is left, right? And they do not come off the deed and the mortgage, right? Then the second party passes away. Now you've got a mess. There's no will. And then the second party on the deed, they may have children as well, or they may have survivors. One party may not have survivors, but it's both parties, survivors, who have to be notified, correct? It's like one big melting pot.
Well, I mean, there's a lot of factors that are going to play into that. Number one, how do they hold title? If it was tenants in common, now you have to have two estates opened up, right? Because they both have an estate. If it was held as joint tenants, then when the first party passed away, it automatically transferred over by operation of law to the other remaining grantee on the deed. Then when that person passes away, it'll either pass via their will or the intestacy statute, which if you don't have a will, there are statutes in every state that will dictate how your assets will pass. And that may or may not be the way that you want them to pass. So it could, again, depending on who survives, it could be distant relatives. And maybe you don't want it to go to those distant relatives. But there's a hierarchy of who is going to receive assets under the intestacy laws.
Okay. And so then you have to go to court and have that all.
Well, someone's going to have to be appointed administrator, and then they're going to have to figure out, okay, well, who's going to receive assets and, you know, in what percentage, because it can get complicated, because if one of the potential heirs predeceased under the intestacy laws, and if they had kids, for example, now maybe you have some of those assets going to those kids. Mm-hmm. So it can be complicated. And now we're talking about, you know, inheritance tax returns and things like that, which, you know, if you want to get into waivers, we can get into waivers. So so whenever someone is going to go sell a piece of real estate through an estate, the title company is going to want to see the waiver, right? They want to make sure that you paid all the taxes that you were supposed to pay.
Yep.
Otherwise, you know, the title company doesn't want to be on the hook for any of that.
Nope.
So the title company, if you don't have a waiver, they're not going to release all the proceeds. They're going to hold a substantial portion of those proceeds in escrow until you present the waiver. Now, you can either get the waiver by filing something called an L9, and then you record that with the county. Or if you can't file an L9, and the reason, so the only way that you can file an L9 if all the beneficiaries are Class A. Class A beneficiaries are bloodline, so parent, spouse, child, grandchild, right down your line. So those are Class A beneficiaries. If all your beneficiaries are Class A, you can file an L9, record it with the county, and that's your waiver you present to the title company. If not all the beneficiaries are Class A, now we have to file something called an inheritance tax return. New Jersey has an inheritance tax. So if you're leaving assets to anyone other than Class A, there's going to be a tax on that. And the only way to get a waiver is to file the return, pay the tax, and then the state will issue a waiver. Now, the inheritance tax return is not due until 8 months after the person passes away. And you can imagine how many tax returns they get. So the review process takes quite a bit of time. Maybe you get selected for audit, maybe you don't, who knows? Then they issue you a waiver. So you can be you can either be held up on the sale of the real estate, or the proceeds will be sitting in escrow for, you know, a year or so until you get that waiver. So we're going to make sure that try to get as much done as you can ahead of time.
Or just go see my friend Chris and get your will set up, and we don't have to deal with this.
That'd be helpful.
Oh my God, how about that? Let's go there. So executor versus the admin, we talked about that. Intestacy.
Yeah, we talked about the intestacy statutes. Those are statutes that, again, they're going to dictate how assets pass if there's no will in place. What about carrying costs? So what if there's a piece of real estate in an estate that forms part of an estate? Real estate taxes still have to be paid. Utilities probably still have to be kept on. We don't want the pipes freezing, right? The lawn has to be mowed. So there's still ongoing carrying costs. Now, who pays that? It should come from the estate.
Right.
But, sometimes there's complicating factors. What if there's not any liquid assets in the estate? There could be a number of things that go on. So maybe one of the beneficiaries or the executrix pays the carrying cost and they get reimbursed at settlement.
And they do get reimbursed fully at settlement.
Yeah, you can get reimbursed.
If there are enough proceeds.
Yeah,
right. And so where do they fall in that line? I feel like it's a valid question.
The cost of administration and everything else is up there with, in relation to taxes and everything else. But that brings up a good point. What if the debts of the estate exceed the value of the estate?
Right.
Well, now you also have a hierarchy on who gets paid first, but the executrix, they don't get to make that decision haphazardly. Now we have to file something in court called an insolvency proceeding. And what you're doing is you're telling the judge, hey, judge, here are our assets. Here are our debts. There are more debts than assets. So please tell me who I get to pay first and in what amounts. Because now if you don't do it properly, now the executor or the administrator, now they're on the hook for payment of those debts potentially. So we want to go to court and say, hey, judge, we've notified all the creditors. What do we do? And then the judge will say, okay, you're going to pay X, Y, and Z, this amount. But administrative costs of debt, taxes, like all that's up near the top.
And so what if an administrator gets into this and says, this is just too much. I'm done with this. I'm not doing this anymore. Right? Then what? And if there's no one else to step up to the plate, then what? What happens to the estate? What happens to the property?
That's a very good point. So if you're a named executor under a will, if you decide, hey, I'm going to take on this responsibility, I'm going to probate the will, and the surrogate issues you short certificates, now you have a fiduciary obligation to properly administer this estate. If you don't, you could be held liable in some circumstances. So once you take on that responsibility, you need to see it through to the end. Now, there's no obligation. If you're a named executor under will, you're under no obligation to take on that responsibility. So there could be some instances where, the person doesn't want to do that. And then they can just say, I'm not going to do it. Now, if there's an alternate executor named, the primary executor can renounce their position, and then the second one can take over. Or if no one wants to do it, there's no obligation for anyone to do it. Just because you're named, you don't have to take on that obligation. But once you do, now you're in a position where you have to finalize it. It's yours. That's right.
You're holding that sucker to the end.
That's right.
And so then what can the penalties be? Like you get into this and you say, like, really, I'm walking away.
Some creditors can go after executors personally.
Right.
So, for instance, so there used to be a publication requirement in New Jersey where you had to publish and say, hey, this person passed away. If there are any creditors there, then come forward. You don't have to do that anymore. Creditors have an obligation. If they want to make a claim against the estate, they have to file a claim with the surrogate. So if the executor fully distributes the estate before that time period has elapsed, then the creditors can come after the executor. Now, if the executor has waited until after that time period has elapsed, and then they paid all the taxes, they've done everything properly, they've then made distributions to the beneficiaries, then that's the creditor's fault that they didn't come forward in time. Now, if the executor knows there's a debt out there, then they should be paying those obligations.
Okay. And the same for the administrator, right? If you take on role of administrator, it's the same thing.
Correct. Same thing.
Okay.
Yeah.
What if someone's living in the property, right? Like a third party?
That's fine, right?
Yeah,
you ever try to
my favorite.
Show a piece of real estate when someone's there that doesn't want you showing the real estate?
Yeah,
right.
My favorite.
So that can be difficult. What if there's a tenant there? What if the tenant is a holdover? What if there's a family member living there and
paying or not paying?
Right. Yeah, exactly. Maybe they're paying, maybe they're not paying. Maybe they decided, I'm not going to pay anymore.
Right. And then just mix in a little COVID.
Right. Not complicated at all, right?
No.
Yes, and now maybe there's an ejectment action. It can make things very difficult. And sometimes we even see it where one of the kids will go in and then they just want to start living there.
Right.
Well, even if everything is at least on the surface kind of friendly, the executor still maybe has an obligation to make sure that the estate is properly preserved. So if someone is living there, the other beneficiaries have the right to have that piece of real estate be productive. So that person that's living there should be paying rent, even if it's a reduced amount of rent, because maybe they're also a beneficiary under the estate. But if the other beneficiaries want that piece of real estate to be productive, then that person should be paying rent to the estate, and the estate will obviously be paying, if there's an outstanding mortgage, they'd be paying the mortgage and carrying cost of the property and things of that nature. But the other beneficiaries have a right for the assets of the estate to be productive during the pendency of the action.
So in the event that the executor or the administrator is not doing what's in the benefit of the estate, what can the other beneficiaries do? Is there any action for them to take?
They can. Courts are hesitant to remove an executor of an estate absent some kind of malfeasance where they're doing something improper. If it's just because they're not collecting rent and someone filed an action to remove the executor, I don't know that a judge would really remove the executor, but the judge would probably say, hey, you need to collect rent from this person. Now, if the executor if they're breaching their fiduciary obligation to the other beneficiaries, then the other beneficiaries can file a complaint in court to have the executor removed. The judge looks at it and the judge feels that the person is not doing what they're supposed to be doing, or they're delaying the administration of the estate, or they're absconding with funds from the estate or what have you, then they can remove the executor and appoint someone else.
Okay. And then that goes back to go see my friend Chris.
Yeah. Did you have an alternate?
Yeah. Did you have an alternate? About that.
So make it easy for everybody. Get your documents in place. So much can be avoided. So much headache can be avoided.
Those are just words to my ears. I love it. Is there anything else you'd like to, mention? Because I know that we're getting close on time and I want to be respectful of your time. I could talk to you about this all day. I think it's fascinating. So fascinating.
I think you're doing a great job just advising your clients, because then just making sure people are educated about it is what's important so that they can make a decision. Sometimes we'll have clients come in and they'll say, Chris, I need a trust. Mm-hmm. Okay. Well, why do you need a trust? My neighbor has a trust, so I must need a trust if my neighbor has a trust. Well, I don't know your neighbor's situation, so maybe you need a trust, maybe you don't need a trust. What kind of trust do you need? Revocable, irrevocable? We have to look at tax issues. What are you using it for? But I think, just educating people, letting them know that there are options out there, what those options are, and then you can make a decision based upon what meets your goals and your family's needs, and then get it done, put it away, revisit it if something happens, but at least you're covered.
Yeah, I feel like it's one of those things that like feel so scary, right? So people just don't want to like walk through that door when really the scary part is after the fact when something happens and you're forced to walk through the door. Like there's so much that can be done, I feel like, and save you money also if you just deal with it up front and get it done, lock it away, revisit it every 5 years, or if again there's some life event that happens, and keep it moving. Like it doesn't have to be this big scary monster in the room.
Yeah.
You
People
know.
love to procrastinate, and this is one of the things that they procrastinate on. Is that if you're young, you feel like you're invincible. Nothing's going to happen to you. And
Until
if
it
you're
does.
right, and if you're older, it's just something. Hey, well, that's not important right now. Listen, it'll take us maybe from the time you come in to the time you sign your documents, maybe 3-4 weeks. We'll be done. It'll be painless. You only have to visit me twice, probably, so you don't even have to come in that much. We can do everything by Zoom, so.
Right, everything by Zoom. My God.
You can stay in your kitchen and visit with me, so.
You can, as long as the Zoom works. God,
Right.
everyone's not on at the same time. Well, thank you again, Chris, for joining me today. I look forward to chatting with you soon. And everyone, Chris's phone number is in the scroll bar. If you have any questions or you have a state that needs to be dealt with, or you just purchased a home or had some life event, Chris would love to chat with you. So thanks again.
Thanks.
And I'll talk to you soon.
All right, thank you. Have a good one. Bye.
Welcome. You as well. Bye.